Hey folks, this is Rob Wells here with you from the law office of Robert M. Wells. Our office helps out landlords and property managers deal with their landlord-tenant situations and problems. In this video, we're going to talk about whether or not an employee's termination of their employment is just cause for terminating any right to remain in your property under the Tenants Protection Act of 2019. Now, before I talk about this, landlords, property managers, if you're facing a situation where you might have terminated an employee and you gave them housing and you terminated their employment and you're having trouble getting that employee out of your housing, please feel free to reach out to us below. Now, let's begin. Now, this is kind of a nuanced type of eviction where you might have an employee or agent or some type of licensee, which is, a license. All a license is permission to do something, and you can terminate, permission at any time. That's what a license is. You may have a situation where you have an employee, you give them housing, and as part of their employment. The classic examples that would probably apply for some landlords that that were easy to follow along are you have a resident manager. They're apartment owners. If you have so many units, you're required to have an on-site resident manager to handle landlord-tenant issues, with the property. So you may hire that person as an employee to work with you, and you may have to sever their employment. So the question becomes, hey, do you have to give is that just cause under the Tenants Protection Act for starting an eviction? And the answer is yes. And this is actually written into the Tenants Protection Act as well. Traditionally, and I'll have to step back a little bit. Before the Tenants Protection Act, it's always been the law in California that if you hire an employee and you give them housing as part of their employment, it's just part of the scope of, what they're going to be doing, such as a resident manager. Another one I can think of off the top of my head is you hire a care provider, to care for a loved one, and that care provider lives on site with the person they're taking care of, your loved one, basically, because they need 24-hour care. That would be something where if you had to terminate employment under traditional California law, you immediately have to vacate the premises. You don't have to give notice of, a 30 or 60 day notice telling that person, hey, you're going to have to vacate in 30, 60 days. Once you terminated their employment, their right to be in the premises ends at that termination of employment. That's been the law for many years, and the Tenants Protection Act is codifying that in here. So the answer is yes. That is just cause under the Tenants Protection Act, and you can certainly do an eviction for that. This is kind of a really nuanced deal because sometimes you may have employment contracts that they're not necessarily clear, and in some cases you may actually, this type of eviction wouldn't work if the employment and the housing were separate items, such as, let's say you live on site, but then you have an agreement for rent, payment of rent to you as the landlord or the property manager. This employee exception's not going to work. What the legislature and the old rules were before the Tenants Protection Act intended was, hey, you, in order to do your job, you have to live at the property, basically. So if you have a separate type of rental agreement where, hey, you're paying rent or you may get discounted rent, this type of eviction may not work for you. You may have to do the traditional 30 or 60 day notice and so forth like that. If you do have a situation that's like this is probably best to really speak with a legal professional that does evictions, that does terminations of tenancies, because a few key facts can change the outcome of the case here. So it's not really as a clean cut rule necessarily. They're really highly factual scenarios, and I've done many of these before in my career. So some of which really rided on a couple of facts of whether or not rent was paid, or was it an issue? Did the landlord give over possession of a certain room, and so forth? So moral of the story is it depends, but it is in the Tenants Protection Act that this is cause if you terminate someone's employment, your agent's employment. That is just cause under the Tenants Protection Act. So if you have that situation, I invite you to reach out to us below. And until next time, folks, we'll talk to you then. Thanks.